Good morning. My name is Greg Frank, and I'm going to go through a couple instructions. I'm going to have the planner go through a couple instructions, and then we get to listen to what you have to say. We'll go on the record now. The time is about 9 in the morning on December 4th, 2025. This is the hearing for Deschutes County file number 247-2500309-CU. As I indicated, my name is Greg Frank. I am the assigned hearings officer for this case. And before we turn to the matters of the hearing, I would like to turn things over to Planner Stewart to describe how the electronic process is going to work this morning. Ms. Stewart.
Good morning. For the record, my name's Audrey Stewart, and I'm an associate planner with the Deschutes County Planning Division. The item before the hearings officer is a conditional use permit for fill and excavation within wetlands and floodplain. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing, followed by a brief presentation on the application. The county has established time limits for testimony as follows: 30 minutes for the applicant, 10 minutes for public agencies, 3 minutes for the general public, and 10 minutes for the applicant's rebuttal. However, the hearings officer can modify or eliminate these time limits. When the testimony portion of the hearing begins, the applicant will present first, followed by agencies, next those in support, then those in opposition, and finally anyone neutral to the applicant's request. Afterwards, the applicant will then be afforded an opportunity to present rebuttal testimony. And finally, staff can make closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first and last name, as well as your mailing address. For our in-person participants, if you'd wish to testify, please add your name to the sign-in sheet over here. I'll use this list to call up participants for their testimony. After your name is called, please come up to one of the tables at the front of the room before beginning your testimony. For our remote participants, if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When Hearings Officer Frank asks if anyone attending remotely would like to testify, you'll need to use the raise hand feature to notify staff. To do this, you'll need to press the raise hand button on your computer or smart device, or if you've called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me. If you're in person, please submit your written testimony to me after your oral testimony. If you're participating remotely, you can submit your written testimony via email to audrey.stewart@deschutes.org. Hearings Officer Frank and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. Are there any objections to the format of the hearing? If you are attending remotely and have an objection, please use the raise hand function. Seeing none, I will turn the hearing over to Hearings Officer Frank.
Thank you, Ms. Stewart. As Ms. Stewart described, we are following the normal hearing procedures in the county code, and I will provide sufficient opportunity for everyone to participate at an appropriate time. I'd ask for your patience as we make sure we get through each of the steps just outlined. The applications being considered through the quasi-judicial process, I will consider only the factual evidence in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing the hearing. They are also set forth in the staff report. The public notice and staff report are posted on the county website. I'm assuming that's correct. No, right. And they are also available here in the hearings room, and just make a request to staff. It is important that you direct all your testimony to the standards and applicable criteria. If you believe a criterion applies that was not listed, then you may address that unlisted criterion. However, I urge you to explain why that criterion must be applied and to do so with specificity so that other participants may respond and so that I can address that issue in my decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes your ability to appeal that issue at the Land Use Board of Appeals. Also, the failure to raise constitutional or other issues relating to any proposed conditions of approval with enough detail to allow me to respond to the issue and my decision precludes an action for damages in circuit court. As I just noted, I serve as a county hearings officer in this matter. In that role, it's my job to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant in this case. To that end, I'll state for the record, I do not have any relationships with the applicant, and I am not aware of any connections that I may have with other participants in this proceeding that would prevent me from remaining impartial. I have communicated with staff, but only to discuss particulars of today's hearing and not the substance of the application. In other words, we talk about scheduling and things like that just to make sure that I get in the same place you're at. I do not have any ex parte contacts. It is my obligation to preside over this hearing in an efficient manner. And do we have an idea of how many people we're going to have testifying today, Ms. Stewart?
Right now, there are four members of the public over Zoom.
Thank you. Okay. Um, what I'm going to do now is I'm going to tell you that, in fact, I'm just simply going to ask, does anybody here, whether online or in person, have any objections that I continue to be the hearings officer in this case based on my representation that I don't have any interests in either the county's position or the applicant's position or anybody in opposition's position? Anybody object to my continuing?
Here. Yeah, one of our Zoom attendees has their hand raised. We can promote them so that they can unmute and we can confirm if it's a comment related to this. And Sally, you should be able to unmute yourself. And Sally, you are unmuted. If you'd like to begin speaking, we should be able to hear you. Sally, it looks like you've been unmuted if you'd like to begin speaking.
Okay.
They muted themselves again, so we're not sure if they.
Okay. Sally, this is the hearings officer, Greg Frank, and the question that I asked, and you may well have a response to it, and I respect that, is whether or not you object to my continuing to be the hearings officer in this case. I just want to distinguish that from you having an opportunity to testify in this case. You're certainly going to have an opportunity to do that. But if your concern is my impartiality or ability to hear this case, that's what I'm inquiring about right now. So could you let us know? Are you concerned about me being the hearings officer? And I will just tell you from my perspective, I can't hear, I have no response on your part, and that doesn't mean it's your fault. There may be some technical issue going on here that I don't understand. Um, should we suggest that she calls back in and tries once again, or what's?
Good morning, Variance Officer Will Rose, Planning Manager. I'm going to recommend that that Sally, because we're not able to hear her, that she send an email to me. Hopefully that method of communication is available to her. And my email address is willg, WILLG, at deschutes.org. That's DESCHUTES.org. So willg at deschutes.org. Sally, if you have any objection to the hearings officer proceeding as the referee in this matter, please send me an email and I will communicate that to him. I'll be watching my email. If you're just hoping to testify later, there will be a specific time for you to do that and you will be asked then. If you have ongoing problems with the communication, we can't hear your audio on this end. Hopefully you can hear ours. You could include your testimony in that email to me, or indicate that you'd like an opportunity during a post-hearing open record period to provide additional testimony. We apologize for the technical difficulties and definitely want to receive the information that you want to convey to us today.
Thank you, Mr. Gross. You have certainly my authority and permission, if in fact you hear from Sally, to raise your hand and let me know what's going on. I'm going to proceed as if there is no objection at this point in time. If it is raised during the course of the hearing, I will deal with that. Just for the general consumption is that I've been very honest, and my name is Frank, but I've been very frank about the fact that I have no interest in any way, shape, or form in the application, other than making the best decision I can. The standards for me to willfully simply say I'm not qualified based on an objection are fairly high. And so I will certainly consider any objections, but I can tell you from very sincerely that I am going to be impartial in this case and would likely decline or deny any objections so that I don't in fact hear this case. All right. So with that, then we'll take public testimony at this point in time. This would be the time and the place for the applicant or applicant's representative. Staff. I'm sorry. Go ahead, staff.
Thank you, hearings officer.
Identify yourself for the record, please.
My name's Audrey Stewart, Associate Planner. I'll provide a brief overview of the subject application. I'll keep this relatively short since the applicant also has a presentation today. The subject property is located at 17147 Blue Heron Drive. The property is predominantly zoned rural residential, but a small portion in the south of the property is zoned floodplain. The property has frontage on the Deschutes River and is also adjacent to a looped canal that extends off of the river. The south property line has an irregular shape, and there's a strip of land that extends along the river towards the outlet of the canal. Under Deschutes County Code, any fill or excavation within wetlands, floodplain, or the better banks of a river requires a conditional use permit. The applicant is requesting approval for excavation and vegetation removal that was done to expand a boat landing area. The application materials include a wetland delineation, which estimates that 8.9 cubic yards of material were excavated from wetlands and 6.1 cubic yards were placed back in wetlands, with the remainder placed in the upland portion of the property. The applicant added other site improvements and landscaping features such as rock retaining walls and a paved path from the residence down towards the canal. Section 18-128-270 of Deschutes County Code contains the criteria for fill and removal. Staff asked the hearings officer to determine whether the applicant has demonstrated these criteria are met, specifically related to impacts to vegetation, riparian habitat, bank stabilization, and potential impacts to the flow of water within the canal. New boat slips are prohibited in the floodplain zone, and the applicant presents arguments regarding whether this is a new boat slip. Finally, the site plan shows a number of landscaping features, some of which are located outside of the mapped wetlands and floodplain. In the incomplete letter, staff raised questions regarding whether any of these features are structures that violate the 100-foot setback from the ordinary high water mark of the Deschutes River. The staff report was published this morning. To make sure everyone has a chance to review it and respond to the issues that are raised, staff will request an open record period when we come to that discussion. The project record is available at the link shown on this screen. And with that, staff is available for any questions from the hearings officer.
Thank you, Ms. Stewart. Just as a matter of disclosure on my part, it kind of goes back to the whole, am I impartial or am I able to hear the hearing? One of my normal statements during my opening comments, but I wanted to wait until after Ms. Stewart's presentation, is that what I have read and what I have done and what I believe that I've seen. And normally I look at the record up until an hour or two before the hearing. Ms. Stewart communicated to me just as a matter of procedure that I wouldn't be receiving the staff report until either last evening or this morning. I did, in fact, receive it this morning, which means that I haven't read it, which means that I have certainly no preconceived notions about whether or not staff's correct or incorrect in any of their assertions or facts or arguments. So I wanted you to be aware of that. The two documents that I did actually take some time and look at were the incomplete letter and the response to the incomplete letter, those two. And the reason that I did that is I wanted to have some idea of what I was stepping into and the issues that might be presented in this case. And so I'm aware of the staff's position or discussion, and I'm aware of applicants' discussion to the extent that they are either in the incomplete letter or they're in the response to the incomplete letter and not anything else. So with that, then, I don't have any questions, Ms. Stewart, at this time. This would be the time and place for the applicant or applicant's representative to come forward. Please, first and last name, give us a mailing address, please.
Good morning, Hearings Officer Frank. Christopher Koback, K-O-B-A-C-K. I'm with Buchanan Schmidt, a Bend firm now, and our address, my address remains the same, 937 Northwest Newport, Suite 220, Bend 97703. And I'm here today as the attorney and representative of the applicant, the Hanson Living Trust. Before I get started, I wanted to do a couple procedural things. One is introduce our group, our team. The Hanson Trust is Ron and Joni Hanson, who are seated behind me. We have Greg Blackmore, who put the application together, and we have that's it in present. We have another consultant. We'll talk about this during the open record period, Karen Allen. She's an environmentalist consultant. She did the wetland report, and she's doing ongoing work. She is on an extended trip currently in Nicaragua. So she's not going to be able to participate today. But as staff indicated, we would also be requesting an open record period for a couple of reasons. One is we got the staff report one at 9 o'clock last night and one this morning, and we knew that. Staff was very open with us that they were they were busy, and I understand they're busy. I do a lot of work with them, and it's complicated. So we anticipated that. As is my practice, I've coordinated with staff, and I agree with their assessment that we need an open record period. We'll talk about the duration, and it's going to really involve Karen Allen, my request, later. So what I wanted to do is, and there will be a little overlap. You have some letters that I submitted yesterday, and I tend to like to submit them a little earlier, and I know you appreciate them a little earlier, but with the absence of the staff report, I was kind of holding back because staff in Deschutes County, as you probably have experienced, does a really good job of identifying issues and questions that they want you to answer. And my practice is to get the staff report before I submit my letter so that I can impart to you our position on those questions to help you make the best decision. And not having it, I put together letters that I could, in the absence of a staff report, and address kind of some of what I think are some foundational issues. But there's a lot more information that we will impart on the process during this open record period. But today I'll give you kind of what we can, and mostly really background. We're going to have some people tell you a little bit about the issues from a factual standpoint, but that's more in the second hearing. The first hearing is pretty isolated to Ms. Allen and some legal issues. So as to the background that's going to kind of apply to both cases, and I'll hopefully we can kind of incorporate some of this in the next hearing, and I don't have to do it all over again. But as I said, Ron and Joni Hansen are the settlers of the applicant, the trust. And they live here in Bend. They've lived here for a long time. Ron's in the lumber business, and Joni has done various things, taught school, and then assisted Ron in the family business. They have 3 kids, 5 grandkids. And this is kind of this property they bought in 2018 along the canal and the river is really their getaway. It's where they recreate with their family mostly and friends. And they rehabbed an older house that they bought in 2018. They added a little accessory like man cave pub room. There was an old log cabin that was a remnant of the other owner, and they moved that to the adjacent property that they own. So there's 2 separate properties. We'll hear about the other one later. And then they did some landscaping. And there was an old road that came through the property. You can see on some of the old photographs I put into the record from the 80s. And they improved some of that with at-grade pathways. There's some leveling, terracing of the both properties, and a lot of that has to do with Joni. She's going to tell you a little bit about her condition. She has a very serious physical condition. She's been struggling with it her whole life, and it makes mobility very, very challenging. She requires flat, level, stable ground to ambulate and to enjoy her property. And so the Hansens have made the property usable for her safely. Most of that is on the other case as well, but there, as Ms. Stewart said, the pathways do extend into the 17147 property, tax lot 900. The main issue, though, on that property is this boat landing. And as staff said, there's a prohibition in the code on boat slips on rivers, lakes, and streams. But there's no prohibition on boat landings on man-made features. And that's kind of one of the critical issues here. So we've attacked it 2 ways. Initially, as you saw in my response to the incomplete letter, and my most recent letter expands on this, is you cannot define that man-made canal as a river because there is no definition of river in the code. But you go to Webster and Oxford, and a river is designed as a natural feature. And I've given you some case law in my recent letter that explains how when there isn't a specifically defined term, it is appropriate for our courts to interpret statutes and local ordinances under the Comcast case using the ordinary meaning in the dictionary. So a river is a natural feature. The code also supports that and practices because river is defined elsewhere in the code to be a natural feature. And staff agrees with us on that. For example, the 100-foot high water mark setback or river setback is measured from a river. It's the same term that's used in the prohibition on slips. Slips are prohibited on rivers. The 100-foot setback applies to rivers, lakes, and streams. Exact same terms. Now, staff agrees that the 100-foot setback does not apply to a man-made water feature. I've uploaded an email from staff on this property from 2021 during the landscape management review of the house, where staff agreed that that's the interpretation. And I've given you some case law where our Supreme Court has said when we use the same term in the same statutes and ordinances, it should have the same meaning. So our position is this is not a boat slip at all because it's not on a natural river. It is a boat landing. And therefore it's permitted because the only activity involved was removal and fill, and removal and fill in the floodplain of a man-made feature is a conditional use. So that's how we get to the conditional use. There's a second prong to this. Somebody else up the river in 2017 approached it a little bit differently. And that happens. They said, well, they treated it as a slip, but they said it's a pre-existing non-conforming use. It was here in the 80s before the restriction or prohibition took place, and we're allowed to expand and improve it. And in that case, they put in 7 big posts in the river bed and the man-made canal bed, put some wood structures and built really kind of a nice confined boat landing area. And that's fine. They did it that way. My point is their decision to do it that way doesn't mean that that canal is a river and that is a slip. That's just their choice. They weren't represented. They didn't evaluate it the way I do. I think we're legally correct. But in any event, I've given you some photographs that are really telling. First, before I go there, I provided the record with the history of the canal that the staff was gracious to give me. So this is a canal the easement was created in 1979 for this canal. And the owners all got together, or the developer or a combination thereof, and they constructed this feature. And if you look at the 87 and 89 photographs, I think you can tell that these landing areas were put in all along the canal as part of the canal. They were there before any houses were there. And so you'll see them as these dark areas all along the canal on the Hanson side of that canal. And you'll see one in front of the Hanson's property. So that's where I'm going, is we have an alternative. If you were to disagree with my statutory construction argument, which I think is solid and correct, you can get there the same way that they got to where they got in 2017. It's an existing slip that can be rehabilitated and even expanded. And so the same review would apply. If you agree with me and it's a landing, or if you say it's a pre-existing slip that can be rehabilitated, the only real test is there's two standards, I think, and Mr. Blackmore identified them both. One is the conditional use standards for filling in a wetland and excavating. And the second is landscape management review, which is really nominal. And I've given you the application and the decision from that 2017 case, which kind of shows you how landscape management review for basic, just insignificant fill and removal is nothing. This county doesn't require a landscape management plan of any kind because it's not a structure. It's not a structure, how they reasoned in that case, it's not a structure for which a permit is required. So you don't even have to submit a landscape management site plan. You just look at, and Mr. Groves has explained this in the past in proceedings very well, and that is the landscape management plan is really just about compatibility. Is that use compatible within that scenic river area? And so let's go to the conditional use standards. First you go to the basic ones. Is the site suitable for the use? And you look at the size, topography, and a number of other issues. And I think Mr. Blackmore has just hit everyone in the burden of proof. The site is large enough for a landing for this and the fill and excavation associated with it. It's a riverfront property, so it's kind of uniquely suited for that use. They're all along there. People who buy these properties buy them to use the river. And One of the things you do is you launch flotation devices, paddle boards, kayaks, etc. To do it safely, you need a place to get to the water. And so that you'll see they're all along there. And so we think the site is uniquely compatible for the use. It's suited for the use. If you look up and down the river, there is nothing about it that stands out as being necessarily offensive or incompatible with the environment. It's really just a naturally excavated area where the craft can come in, people can get on and off it safely. And so we've covered the specific or the general ones. The specific elements for this conditional use for fill and excavation really get to the hydrology and the vegetation, as Ms. Stewart said. And so on hydrology, what we've given you today, what we were able to give you is Karen Allen provided me with a video that until I got involved in the case, I didn't really knew exist, but she did a video September 2024, so a couple years after the landing was excavated, and she did her initial work. And you'll see it shows, and she's got an email that I uploaded with it that explains the hydrology from her standpoint, and how there has been absolutely no impact on the hydrology of the river as a result of this fill and excavation of the area. She's going to expand on that during the open record period if you indulge us in the time to allow her to do that when she returns from Nicaragua. And on vegetation, the video does a lot to show you how within that short period of time, the vegetation, the quality, character, everything is essentially the same as it was before. So you'll have some pictures of the before that we have in there, and you can see from that video that the vegetation is essentially back to normal. However, one of the issues I started working with Ms. Allen on was assessing whether there would be a benefit to some form of replanting, a revegetation plan. That's what she does. And so she started that before her travels and is committed to doing that as soon as she gets over her jet lag from her return. And that she'll expand on that a little bit. And then on the next case, we'll talk about the dock. She's going to take a look at some issues there. And so that's kind of what we have on the landing from the two review standpoints. Now, staff indicated that there is now a concern about some landscaping on tax lot 900. And we'll have to address that a little bit more because it was not in the notice of violation on this property. And these applications, I think you're aware, came out of a notice of violation. And one of the things the county and many jurisdictions do is give an owner who has been cited with a violation an opportunity to rectify it through retroactive land use approval. And that's what we're doing. And so the material you have in the burden of proof is a thin at best on these landscape features because they weren't in the violation. So I don't think Mr. Blackmore appreciated that staff would be requiring us to do anything on them. But I would say this, based on staff's position that the 100-foot setback does not apply to the canal, I think most if not all of the landscape features on the tax lot 900 would be allowed because the 100-foot setback doesn't apply. So you would go to the rear setback in the base zone, RR10, and it specifically allows terracing and landscaping. So we'll address that in the open record period to the extent you think it's relevant, even though it wasn't in the notice of violation. But that's where we'll go with it. We think that stuff is intrinsically allowed on that property. And so that's our presentation on the landing/slip. Unless there are any questions, we'll let the public testify, and then I'll come back if necessary and make some further comments. We appreciate your time.
Thank you, Mr. Kovac. I'm going to hold my questions primarily because I don't have enough background in this, factually background, because I'm getting it now, that it makes it harder to ask questions that actually sound intelligent. And so I'm going to hold off with questions, not because I might not have them, it's just that I don't have them right now.
Well, I appreciate that. We're all getting stuff a little bit late.
Right. Thank you. Any additional testimony on behalf of applicant?
Not on this one. We will have some on the next application.
All right. Is there anyone here to testify in support of the application?
On this one, I don't think so. Ms. Allen is our main witness on this one, and as I said, she's not available.
Okay.
And Hearings Officer Frank,
Ms. Stewart,
it appears one person on Zoom is raising their hand. I'm not sure if they are indicating they want to testify in support, or if it's someone who's just waiting to provide testimony.
well, let's find out.
Hi, this is Karen, and I am waiting to comment on the canal and whether it's man-made or not.
So this is the hearings officer speaking. Would you feel appropriate to testify in opposition then?
Yes,
Okay, I'm going to give you a chance to testify, but we're just going to wait just a sec. If you
Okay,
can be
thank you.
patient with us.
sure.
Okay, thank you. So seeing no testimony in opposition or in support, then I guess this would be the time for the opposition. And Ms. Drury, you still there?
Yes,
Oh, good. Would you give us your first and last name and give us a mailing address, please?
sure. It's Karen Drury, and my address is 17166 Wood Duck Court, and I am on the canal on the opposite side. And we're basically on an island, and we recently had to have our bridge to the island replaced. And so there was a lot of research done, and we have documentation from maps from the late 60s that show that our canal was originally a naturally occurring oxbow. So it was part of the river.
So it was an oxbow?
An oxbow is like a loop of the river that has meandered and then been cut off from the river. And so my understanding is that the developers of this property just cleaned out the ends so that the water could flow again.
Okay, thank you very much. Anything else that you have for me? Because this is something that I'm not quite sure. As I indicated to Mr. Kovac, I don't have all the answers on or
Sure.
information. Any additional information you can give me on this would be appreciated.
No, that's the most important part of after listening to what was just presented, because there's a big difference evidently between something that's man-made and something that's naturally occurring.
Agree. Thank you. Anything else, ma'am?
I guess one other issue that nobody's touched on that still seems to be rather important is the spotted frog. And this is one of the few habitats anywhere where the spotted frog lives. And changes to the canal affect the spotted frog in addition to other things.
Thank you. Anything else?
No, thank you.
Thank you for your testimony. Anyone else in opposition? Ms. Stewart, online?
I see two other participants raising their hand.
Okay, that's
Three now. Would the hearings officer like me to call out names?
yes, please.
Okay, we will next move on to Donna P.
And ma'am, if you could identify yourself for the record, first and last name and your address, please.
My name is Donna Pensinger, and I live at 17130 Wood Duck Court, which is just across the canal from the Hanson home. We are actually on the opposite point. So without the canal, our properties would butt up at the point of the river.
Okay.
Okay. The spotted frog has been mentioned, so I'll skip that part. My biggest concern about this slip is not only the slip, but also the point of the river. I did submit 2 photos from Google Earth to Audrey's email just little bit ago. The first being from 2018, where you can clearly see the point of the Hanson property as well as that slip area, that it is solid and filled in with vegetation to protect the silt from running into the canal and or the river. Since this project has started, the point of the river had a wooden structure there that I don't know who put it there, but it was to protect the water erosion of that point of the river. That has been removed. If you look at this year's Google Earth photo that I also sent to Audrey, you will see, in fact, that there's very little land now on that point due to this slip cutout. You can also see in the 2018 photo that it was not a boat slip. It was just like we have on our side. It's a canal with vegetation. The river comes around that way, but it was solid land. If you look at the pictures of today that I submitted also a few weeks ago, you can see that all the vegetation has been removed. Whatever soil was brought in, if there was any, it's depositing now into the canal with water erosion, snow erosion, ice melt. That silt is eventually, in my estimation, going to fill in that end and of the canal and into the river. There's nowhere for this dirt to go. There's been nothing to protect the waterway from this dugout. Let's see, let me double check my notes. I don't know if there is any proof of this being a pre-existing boat slip. I don't know. I've not seen any photos of that. I don't know what year that might have happened. We've owned this property since 2008. And at that time, it was completely covered and natural and had vegetation, and we had this structure to protect the point of the river. So if that is true, I would love to see a photo that shows it as a boat slip at some point in time. I don't believe that's correct. Okay, I think that's it for me. My biggest concern is the future of this situation, in that in the next 3 to 5 years, that channel is going to get filled in, and I can see it already has changed just since this process started 4 years ago. And my other concern is now the Hanson Family Trust is building on the lot next door, different lot number, I don't know what it is offhand. My question is, what are they going to do next to the next part of the canal coming down from that property? Is there going to be more destruction of habitats and our waterway, even whether it's allowed because it's a canal or not? Is there going to be anything that is going to impact in the future without permission? And I think the permission thing is a big issue for a lot of people here too. So, okay, thank you for hearing from me.
Thank you so much for your testimony. Ms. Stewart, do you want to recognize the next person?
And next, we have Sally Schultz.
Hi, can you hear me now?
First and last name and address, please.
Can you hear me?
I can hear you just fine. Thank you.
Perfect. I'm on my iPad now. Yes, my name is Sally Schulte. My address is 17142 Wood Duck Court, Bend, Oregon 97707. I live on the island as well, just I guess a little upstream from the Hanson property. So I kind of want to dispute how much dirt and Phil was taking out when they were developing that slip, because I've owned this property since 2005. And if you look at the Google Earth photos that Donna had submitted, there's no way that was 7 cubic feet. They took out a lot of dirt out of there, and our canal got quite silty in the process. The other the other fact is we were remodeling the same time they were, and we are on the canal. Deschutes County repeatedly had told us that that canal is considered part of the river. It's didn't matter if it was man-made or not, but anything we affected it had to be under the same regulations as the river was, as far as the setback, disruption of anything. We are in the floodplain, so we had to take a year to get a FEMA permit. The county made us follow every single point, to the point of we almost stopped our project following their regulations. And I feel like others just got away with things, and this is one of those situations. We were told not to disrupt the bank at all because it's considered part of the river. And so that's my main contention in that. And I think they took out a lot more fill than what they're specifying. So that's all.
Thank you, Ms. Schulte. I appreciate your testimony. Ms. Stewart, anyone else online?
Next, we have Renee.
Okay. And Renee, same thing as I ask everybody, first and last name, and give us your address, please.
Hi, my name is Renee Eade. I'm at 17136 Wood Duck Court, and also a resident of the island. And my concerns are very similar to what's already been mentioned, but in addition, there's a lot of categorization and a lot of self-reporting that is relied on in the wetlands report. And I don't think this should be categorized as a boat slip. To me, it looks a lot more like a boat launch or a boat ramp. Typically, a boat slip you wouldn't need to excavate, grade, add fill. But what has happened here is a great deal of excavation, grading, filling that is now going to likely clog up the canal, and has created a permanent slope into the water. And to me, it looks more like a boat launch or a beach. And in doing this, my concern is also for the future. And in doing this, they also, which I think was very much glossed over in the wetlands report, they bifurcated an existing wetlands into, zone 1 and zone 2, which is referenced in the report. And zone 2 is just a tiny little triangle of wetlands. And I have not seen anything done to address, the damage done to the vegetation or to create a plan for the bank in the future or manage the erosion that's currently going on. So I just don't think the requirements for DCC 18.128.270 have been met. And also I share the concern about the sill, that little point of land that goes out between the river and the canal. And in the wetlands report, it was reported that they maybe took it from 5 to 3 or 4 feet. Well, there was also a established pine tree and a lot of vegetation on that point that protected, again, both the river and the canal. And I think that's been very much glossed over and not addressed in any of the planning or permitting here that we're looking at today. I think those are my chief concerns.
Well, take your time. If you have anything else, just let me know.
Okay, thank you.
So did you have anything else? Sorry.
No.
Okay, thank you. I apologize. I didn't mean to interrupt that way. All right. Thank you very much for your testimony. And for all of those who've testified so far, I could have mentioned it earlier, but the record has been requested to remain open both by the county and the applicant. How long and the timeframes of those are to be discussed later, and Ms. Stewart will talk about just how you get information into the record, but anyone wishing to add and supplement what they've testified to today certainly has the right to do that during the open record period. Ms. Stewart, anyone else?
No hearings officer, but it does appear one person is raising their hand, so I'm not sure if it's Karen, who I believe has already testified, but she does have a hand raised.
Okay, Ms. Drury's already testified. Is that the same person?
Yes.
Okay, Ms. Drury, you'll certainly have an opportunity during the open record period to submit any additional testimony you have. Each person, other than the applicant and the staff, gets one opportunity. I'm not trying to exclude you. I'm just saying that you're going to have every right to submit in writing anything that you wish to add to your earlier testimony. And I do appreciate your testimony. So with that, and going back, we had a Sally originally was potentially objecting to my participation. Have we heard back from her?
That was Ms. Schulte who just testified. It appears she joined on a different device and was able
Oh,
to.
excellent. I appreciate that. All right. Anyone else in opposition, Ms. Stewart?
No one else, hearings officer?
All righty. Anyone neutral? Anyone doesn't care what side they're on? They just want to give me good information. That's always nice. Don't ever get it, but it's always nice to ask. All right. Mr. Kobach, anything that you'd like to add?
Thank you, Hearings Officer Frank. Chris Kobach again on behalf of the applicants. I have a couple brief comments, and then I think Mr. Hanson, I'm going to have him testify and rebuttal a little bit on some of the issues raised just a minute ago. First of all, on the canal, I think the best evidence on the nature of the canal is the whole history that staff gave me and I gave you, where they talk about constructing it. And what is there today, I think, is the issue. And what is there today is a man-made feature. Staff has confirmed that in numerous communications and decisions. In fact, the whole history talks about its creation, and then by 1998, it was so filled with sediment already that the neighbors were trying to gather enough funds from the group to dredge it. And they had a plan and everything. And then maybe 5 or 6 people in the neighborhood held out on money, and so it just never happened. But I think all of that history will confirm the best it can for you, the nature of the construction and that it's a man-made feature, what's there today. We appreciate the comment on the plantings. I think it was Ms. Schulte or the last commenter. That is exactly what Karen Allen is planning to do. We need to get a little bit of definition from staff on the scope of the area. We kind of have a pretty good idea that we want to present to staff. We just want to make sure, Karen wants to make sure that her plan covers the area that staff agrees it should cover. She tells me that's kind of protocol. But she will be putting that together. I didn't appreciate the spotted frog issue. But Ms. Allen is an environmentalist and habitat. She's an expert on habitat as well. During the open record period, we'll have her address habitat and any potential impacts and mitigation required by that. Let me see. Oh, as far as excavation and fill, just want to be clear, we're not claiming that there wasn't excavation. Our position is for 2 reasons. It's permitted as long as we go through the conditional use criteria, which we've done. If this is a man-made feature and a landing, not a river, then the excavation is allowed, subject to conditional use. If you agree with the historical photographs from 87 and 89 that clearly show a landing area in this area as a existing non-conforming use, then I think we're allowed to do what the neighbors did in 2017 and excavate subject to the same standards. So Mr. Hanson, I want him to come up and explain a couple things. We'll be as efficient as we can, but there were a couple comments that raised good points that I think he's best able to respond to. So Mr. Hanson is the gentleman who took the dirt out, and I want him to tell you kind of his recollection of the amount of fill he removed. Mr. Hanson?
Mr. Hanson, if you do me a favor, just like everybody else, first and last name, address.
Hanson.
Thank you.
And my address is 1810 Northeast Cliff Drive here in Bend.
Go ahead, sir.
I'm the one that did the work on that, on creating that boat slip. Excuse me, I have pictures that show that it had been there at one time. So I took those myself. So I cleaned that up with my Kubota tractor, small tractor. What I did is I dragged that back a little bit and just cleaned it up, the vegetation. And that fill came kind of up that hill a little bit. The fill was minimal at that point, it still is. I didn't put anything in the river. I took it actually coming back, which would have helped that area.
Okay, now, second issue. What some people call the thumb and what I've called the spit. Tell us about the history of it since you got on the property and any work you did on that spit.
It appeared to me that they had lined that canal with bentonite. So that little area where I'd started excavating right there on the top, there was a little hill there and it was all bentonite, which was to protect that canal from leaking. Which is kind of interesting because they just left it there. And again, that road came right down there where they brought their trucks into there. So I cleaned that up is what I did.
And then there was an old lodgepole tree or two on
Yeah,
that spit.
yes,
Tell
there
us
was.
about the tree.
Oh, they were dying. I think lodgepole, they just weren't healthy at all. So I did take them out. I think there was probably 3 or 4 or 5 right there, small. Nothing bigger than 6 inches, 8 inches.
And then finally, there was some testimony about a wooden feature on the point to protect erosion. You do know about that.
Well, Audrey had a picture of it and I don't remember it much at all. At the picture, I'm not sure if I remember it from the picture or what was there. I did not remove it. Now, the person that did the landscaping down there, that did that little rock wall down there, I asked him if he removed it and he didn't remember either, but I don't know what happened to it. I did not do it personally. So, and it was broken down. I think you have pictures of it, don't you, Audrey?
There's a picture in the record. I believe it's an old real estate listing photo that shows that small kind of wood, I wouldn't quite call it a fence, some wood that extends along this thumb or spit, this strip of land that extends along the river.
I don't even remember how big, it was very small and it was pretty, it was old. It looked like it was about ready to fall down.
And then finally, you spend a fair bit of time out at your property. Have you noticed on that spit area any additional erosion since you've done your work?
I have not. And the water flows on that canal. It would actually flow from my property out into the river, not upstream, up the canal, because the water comes around in a loop. So we're at the downstream, downriver part of that loop on that canal. So I have not noticed anything, but the river does change all the time out there.
Okay, that's the scope of our rebuttal. And again, I'm assuming no questions because we're getting a lot of stuff new, but we're here.
I appreciate it. Okay. Thank you, Mr. Hanson. I appreciate your testimony. As Mr. Kovac indicated, that's the extent of the applicant's rebuttal. Ms. Stewart, any comments?
No other comments from staff.
All right, let's talk about then the open record period.
Absolutely.
And I don't care who goes first. You can, as a matter of politeness or courtesy, defer to one another. But however you want to do it, let's get dates and times and things out on the record.
As mentioned before, staff is going to request an open record period. Again, just to make sure everyone has a chance to respond to the staff report and then issues raised today. I have dates shown on this screen here. If the applicant requests a 7/7/7, from their discussion, it sounds like they might request a longer open record period, so staff would turn to the applicant.
Thank you. And here's Officer Frank again. This is kind of I know the 7/7 is typical. I've had 14/7/7. This is the first time I've had one this unique where I need to plead my case for a significantly longer initial period. And I think the circumstances warrant it. One is there's issues that have been raised by staff, and I assume they're in these staff reports as well that we just got. And there's issues that were just raised today on the spotted frog and some other stuff that, frankly, I can't respond to, nor can my clients effectively. And to present their case and give them, I think, the process that they should have, we really need Karen Allen to come back and give you the spotted frog habitat analysis and the quality and density of vegetation analysis and a replanting plan. Now, Ms. Allen, she's in Nicaragua, and I pinned her down. She arrives in Oregon on December 16th if everything goes as planned, at 2:00 in the morning. And so she will get to Bend sometime early the morning of December 16th. And I didn't ask her how much time she wanted. I was very clear in asking her how much time she needed. And she said she needs a few days to get her legs under her. This isn't her only case. And then she would she feels she needs about 10 days to actually get this work done. And so if she gets in on the 16th, I would really be asking for the indulgence of having until the last week of December, like the 30th or 31st, to allow Ms. Allen to complete her work and submit her report. After that, 7 and 7 is fine. I have no concern. It's not really about me, and it's not about anybody else in our case, but it is an important issue, and I have no control over that. I can't hire a new consultant, and I don't think a new consultant would give the process justice because Ms. Allen's already done a lot of the work out there. She's familiar with it. I think she's going to give you and staff and the public participants the very best information available.
Okay, Mr. Kovac, I just tell you my general philosophy is I don't have, other than the statutory requirements or the code requirements, going longer is not an issue unless it impacts the time that the decision has to go out. And so I'm just going to ask for staff's input on where we stand on the deadline for a decision, and given an opportunity, if in fact there's an appeal, to have the commission review the matter. So, Mr. Kovac, I don't care if it goes out a month or 2 months. It really doesn't matter to me. Eventually, I have to sit down. Eventually, I have to make sure I understand what's going on, and eventually, I have to issue a decision. But the one thing I won't do is miss deadline. And so with that, all I care about is where staff comes on that. I'm not giving them discretion other than the deadline.
And Hearings Officer Frank, in Title II, which is our procedures ordinance, it states that days that the applicant has agreed to for the open record period don't count towards the 150-day clock. So staff doesn't, in this case, staff doesn't have concerns if the applicant is requesting a longer.
That is true, and to the extent you need clarity, the applicant is willing to toll the 150-day or any other period that's within our control to allow our request to be granted.
Okay.
And
So I'm sorry, Ms. Stewart, I didn't mean to interrupt.
Hearings Officer, staff will follow up with the applicant about that. Just
Well, give me-
again, just to make sure.
Give me a date that you both agree on, so you can talk between yourself and forget me for just a sec.
Well, I think I came up with the date of the December 31st. That gives Ms. Allen about 10 days after she gets her feet under her. I think she's going to have probably tons of emails and other things to respond to. So I think she probably will get to it the week before, the week after she gets back, and then she's got the Christmas holidays. We all do. So I was thinking if we gave her till the 31st of December, that would be a sufficient time for her to complete her work.
That is a Wednesday?
That is a Wednesday.
And then are you proposing after that just 7 for rebuttal, 7 for response and 7 for rebuttal?
That would be what the applicant would need. If staff feels that more time is required, they've indulged us, and we'd be happy to indulge staff.
Stuart?
Staff doesn't have specific concerns with a 7-day open record period. Again, understanding that sounds like a significant amount of new information might come in during this initial open record period. Staff is also supportive of a longer rebuttal period if the applicant needs it.
So the 31st, then the 7th, and then the 14th, if everybody has their calendars, would everybody make sure that those dates are okay?
They are. And once we've nailed down those dates, I do have some reminders for the group about just open records medals.
Mr. Kobach, that's okay with you?
Let me just,
So it'd be the 31st for new evidence, 7th for responsive evidence, and 14th for final argument or final rebuttal.
that works for the applicant. Thank you.
All right, Ms. Stewart, then I'm going to turn it over to you, and you can revise your screen or update your screen. But I need your instructions on how people, whether they're here or online, get information during the times that we have just agreed to.
Thank you. So to recap for everyone, the open record period will be that new evidence and testimony can be submitted up until 4 p.m. on Wednesday, December 31st. Rebuttal testimony can be submitted up until 4 p.m. on Wednesday, December 7th. And this is testimony that responds to materials and arguments that are already in the record. And then the applicant will have up until 4 p.m. on Wednesday, December 14th to submit their final legal argument. As some reminders about the open record period, all submittals should be sent to me at audrey.stewart@deschutes.org. Deschutes County does not take responsibility for retrieving information from a website link or a personal cloud storage device. And electronic submittals must be received by the county server by 4 p.m. on the date of the deadline, so please do not wait until the last minute to submit your materials. And with that, I will turn it back over to the hearings officer.
Okay, thank you. So, Mr. Kobach, any questions about the comments from staff regarding the open record period?
No, thank you.
Okay, then the record will remain open for new evidence until 4 p.m. on December 31st, 2025. The response period, which ends at 4 p.m. on the 7th of January in 2026, is, as Ms. Stewart described, only in response to what is in the record. There's no new evidence comes in there. And I will tell you that I have had experience with attorneys representing applicants being very concerned and looking at evidence that comes in during that, I call it second period, up until the 7th. That is new evidence, because I will not consider that new evidence, and usually somebody points out that there is new evidence in there. So just be responding, and just be respectful and respond to what's in the record at the time. And finally, Mr. Kobach, on behalf of the applicant, you will have the right to submit your final argument or rebuttal by 4 p.m. When I referred to Mr. Kobach having the right to submit a final rebuttal or final argument, that is a statutory right granted by the state of Oregon only to the applicant in this case. So if you wanted to respond to something during that last week, unless you're the applicant, you can't do that. I'm sorry, but that's just the way the rules work. I issue my decision on the case based only on what evidence is in the record and what arguments are made in the record. And so I will do that within 21 days of the 14th of January. I didn't run that out, but it's sometime in February of 2026. So with that, are there any comments or questions from staff before we close the hearing?
No comments from staff.
Any questions or comments from the applicant? All right, we'll close this hearing at this time, and we are going to go into another hearing. But I'm going to take about a minute just to get my space cleared up and make sure I'm looking at the right thing. But we will start, and I'm not sure how you're going to do it. If you're going to cut us off and then tell me that we're back on the record, just help me out on that one.
And if I may, hearings officer,
Go ahead.
just for the benefit of anyone who's watching, it will be the same Zoom link for the next hearing related to the neighboring property.
Thank you for that clarification. All right. So let me get organized here. Okay. We'll go on the record right now. For those of you who are sitting in front of me, I'm not trying to waste your time. And those of you who are continuing or back for this hearing that are online, I'm not trying to waste your time as well, but I'm going to go through pretty much the entire opening spiel that we had for the first hearing as just making the record as clean as possible. So bear with me if you would, please. We are on the record now. The time is about 10:13 on December 4th, 2025, and this is the hearing for Deschutes County file numbers 247-25-0000306-CU, 247-25-0000307-LM, and 247-25-0000308V. My name is Greg Frank, and I am a hearings officer in this matter. I have been assigned by Deschutes County for this matter. Before we turn to the particulars of the hearing, I would like to turn things over to Ms. Stewart to describe how the electronic process is going to work in this hearing. Ms. Stewart.
Good morning. For the record, my name's Audrey Stewart, and again, I'm an associate planner with the Deschutes County Planning Division. The item before the hearings officer is a conditional use permit for a dock, landscape management review for accessory structures, and a variance to the 100-foot river setback. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing, followed by a brief presentation on the application. The county has established the following time limits: 30 minutes for the applicant, 10 minutes for public agencies, 3 minutes for the general public, and 10 minutes for the applicant rebuttal. However, the hearings officer can modify or eliminate these time limits. When the testimony portion of the hearing begins, the applicant will present first, followed by agencies, next those in support, then those in opposition, and finally anyone neutral to the applicant's request. Afterwards, the applicant will then be afforded an opportunity to present rebuttal testimony, and finally, staff can make closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first and last name, as well as your mailing address. For our in-person participants, if you wish to testify, please add your name to the sign-in sheet up here. I will use this list to call up participants. For our remote participants, if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When Hearings Officer Frank asks if anyone attending remotely would like to testify, you'll need to use the raise hand feature to notify staff. To do this, you need to press the raise hand button on your computer or smart device, or if you've called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me. If you're in person, please submit your written testimony to me after your oral testimony. If you're participating remotely, you can submit your written testimony via email to audrey.stewart@deschutes.org. Hearings Officer Frank and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. Are there any objections to the format of the hearing? If you're attending remotely and have an objection, please use the raise hand function. Seeing none, I will turn the hearing over to Hearings Officer Frank.
Thank you, Ms. Stewart. As Ms. Stewart described, we are following the normal hearing procedures in the county's code, and I will provide sufficient opportunity for everyone to participate at an appropriate time. I'd ask for your patience to make sure that we get through each of the steps just outlined. This application is being considered through a quasi-judicial process, and I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county comprehensive plan and land use regulations. The standards and the applicable criteria relevant to this hearing were identified in the public notice to the hearing. They were also set forth in the staff report. The public notice and staff report are posted on the county's website, and they were also available directly from staff upon request. It is important that you direct all your testimony to the standards and the applicable criteria If you believe a criterion applies that was not listed, you may address the unlisted criteria. However, I urge you to also explain why the criterion must apply and to do so with specificity so that other participants may respond and so that I can address any issue, such issue in my decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, failure to raise a constitutional or other issue relating to any proposed conditions, of approval with enough detail to allow me to respond to the issue, and my decision precludes an action for damages in circuit court. As I just noted, I serve as a county hearings officer in this matter. In that role, it is my job to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or any interests of any other participant. To that end, I will state for the record that I do not have any relationship with the applicant and that I am not aware of any connections that I may have with other participants in this proceeding that would prevent me from remaining impartial. I have communicated with staff, but only to discuss the particulars of the hearing, primarily procedural aspects, and not the substance of the application. I do not have any ex parte contacts to disclose. I'm going to ask at this point in time, is there anyone here in person who objects to my participation as the hearings officer and ultimately issue a decision? Ms. Stewart, could you check online to see if there's any objections to my participation in this hearing?
No one online is raising their hands.
All right. I'm going to now turn it over to Ms. Stewart, and she is going to present the staff report. Following the staff report will be the applicant's opportunity to present their testimony or presentation. Ms. Stewart, and as I indicated earlier, first name, last name, address, everybody, no exceptions. All right, Ms. Stewart.
Thank you, hearings officer. I'll now provide an overview of the subject applications. The property is located at 17133 Blue Heron Drive. The property does not contain a dwelling, and it's developed with an accessory building, play structures, and a dock. The property is under common ownership with the adjacent property to the east, which does contain a dwelling. The subject property is mostly zoned rural residential, and a small portion in the south of the property along the Deschutes River is zoned floodplain. This portion in the south area of the property also contains mapped wetlands. The applicant requests approval for an expansion of a dock. The dock has existed since at least 2012, but has not previously received land use approval, so is reviewed under the current provisions of the floodplain zone. The applicant also requests landscape management review for an accessory structure and a variance to the 100-foot river setback for a number of play structures that were constructed, including a deck, a treehouse, and a zipline landing pad. And the image here is a snapshot of the site plan submitted by the applicant. The staff report has identified several issue areas for the hearings officer to address. These include the standards for docks in the floodplain zone and whether the dimensions, design, and construction methods of the dock meet these standards, whether the associated fill and removal within wetlands and floodplain has negatively impacted riparian vegetation, bank stability, or other characteristics of the river. And third, Section 18-120-030 of Deschutes County Code provides specific setback exceptions, which the applicant argues may apply here and therefore provide an alternate path that does not require a variance. And finally, has the applicant demonstrated that they qualify for a variance to the 100-foot river setback? The record is available at the link shown on the screen here. All materials received as of 8 a.m. today have been uploaded. And once again, the staff report was published this morning, so staff will again support an open record period.
Thank you. As I indicated in a prior hearing, and so I'll just reiterate it, I received the staff report this morning. So I have not reviewed it. So if you assume that I have, that's not correct. What I have reviewed in this case, well, in two cases, but in this case in particular, is I have reviewed the incomplete letter, which gave me background generally on the property and applicant's response to that. So with that, that's pretty much what I have reviewed in this case. So I'm not starting from scratch, but I'm starting pretty close to scratch on my review of this. So any assumptions you make regarding my knowledge, you're going to have to fill in, and that's actually the purpose of the hearing and the submissions into the record is to give me the information necessary to make the decision. But I just wanted to disclose that I have limited knowledge about this particular case at this particular time. Will change, but it will change. All right. So thank you. I have no questions for staff, applicant. This is time and place for the applicant or applicant's representative.
Good morning, Hearings Officer Frank. Again, Christopher Koback, K-O-B-A-C-K, Buchanan Schmid, 937 Northwest Newport, Suite 220-97703. On behalf of the applicant, Hanson Living Trust. Kind of deja vu. I'm going to go over a little bit of what I did because they're two records. I'm going to skip some of the basics on the purchase of the property, hopefully incorporating that from the prior hearing. But on the procedure, it's kind of the same. You have a letter on the foundational issues that I was able to address without the benefit of the staff report. We will be asking for our own open record period, same as last time, and for the same reasons, and we would support staff's request for the open record period as well. So this is the property, as Ms. Stewart mentioned, that is immediately adjacent to where the Hanson home is. It's although it's totally a legally separate lot, it is integral to the retreat. And I wanted to give you a little bit of background on how it's developed, what it's developed with, and why. So, the main house is on one parcel, and then the log cabin that I mentioned that was there was moved delicately over to the adjacent property. It's not habitable. There's some storage, and the grandkids use it, I think, as a playhouse. Very historic, and then adjacent to that is I'm walking down towards the river, and you'll see some pictures, I think, in the record, is a concrete grade level platform with a basketball hoop. Adjacent to that is a pretty much on grade platform where kids play. Next to that is something called a tree fort. It's a wooden play structure. And then then next to that is the cool zip line landing platform. And then you work down from that point towards the river, and there's the dock. Now, the play equipment was, Ron and Joni Hanson are adoring grandparents, and so this is their retreat. And they built this, they created this for their kids and grandkids primarily. In fact, Joni, I mentioned she's a former school teacher. They have a summer camp where all the grandkids come for a week or two. And this summer, they do like all kinds of activities every day. It's really organized. And then they have a play. And this past summer, my wife and I had the privilege of being there during summer camp, and we got a preview of one of the songs. And so that's what they were creating. And Ron's kind of meticulous. He could have gone to Costco or Walmart and bought some play equipment, pre-manufactured plastic, brightly colored, but that's not how he's wired. So he built some nice wooden play structures for a couple of reasons. One, it just looks good. I mean, he's respectful for his neighbors. He didn't want to put something that's ugly. He didn't want anything that had a risk of floating down the river. He understood that. He's going to testify about his knowledge of the rules at the time, and he's not going to deny that he was aware there are setbacks. He's not naive, but he really looked at this as innocuous play equipment that anybody should be able to have. And so he put it up with good intentions. And it's kind of where it needs to be. You know, on the other side of the fort, there's a corner you'll see in the property up by the road, but it's really isolated from the house. You can't see the kids. For security and safety, this is kind of where they needed it. And so that's where it is. Walking down from the play equipment, there's the path I told you about. It's on the old road that went down to the thumb. And then there's a dock. The dock, I think Ms. Stewart said 2012. I think I've seen that as a date. The Hansons will tell you they really don't know. It was there when they bought it. And like a lot of homeowners, they just presumed it was fine. You know, it would be permitted because nobody said otherwise, right? And it's there. So they didn't do anything there. They put some guardrails up for safety. You know, they have, like I said, Joni's mobility is a little challenged, quite challenged. Stability is important and safety. And since the dock is right at the river, Ron installed some safety rails around the deck and then for the grandkids. And so that's what you have, and that's really why it's there. From a permitting standpoint, I agree with Ms. Stewart's report that the issues are the dock needs a permit. It can be permitted in the floodplain as a conditional use. And it would be a retroactive permit. We've applied for it. The issues there really go to, well, one, the size. We agree. There's a limitation on dock sizes in the code in the floodplain. It's for a single property, it's 180 square feet. And for a community dock that serves two properties, it's 320. And this serves two properties. It serves the main property and it serves the legally distinct separate property. It's 500 square feet. Now, I think you've heard me before and seen my work. I pride myself on working hard for my clients. I'm still working on angles to figure out whether we can keep 500 square feet. But being realistic, Mr. Hanson and I submitted a plan that we came up with this last summer when we were out there on how that dock can be retrofitted to 320 feet, and it's in the record. So there is a plan in place to cut that back, and essentially it's two wings that are landward from the deck that will come off, and they can just be cut off. We don't anticipate any excavation. But that's another element where we're going to have Taryn Allen take a look at it from an environmental standpoint to see to the extent any vegetation might be disturbed in doing that work if it's necessary. If I can't come up with another one of these creative ways to keep it, then she will tell us what we have to do to environmentally safe, remove it. So we'll work on that. As far as the amount of fill and excavation, you know, Hanson's and I have to be candid. We really don't have much to tell you. And I don't think anybody can because it was there. What we can tell you, and what Mr. Blackmore, I think, did an excellent job in the burden of proof, is showing you graphically what's there. And I think you can reach the safe conclusion that the amount of excavation and fill to put that dock in was minimal. It was similar to what you'll read in that 2017 boat slip case. They dug out enough to put cement pillars down or pier pads, and then so that would be the excavation. And then those holes were filled with cement and coated properly, so they complied with the code for doing the work. But as far as the amount of excavation, it's basically the only thing we can conclude is it's the diameter of those piers going down a couple feet, and I think that's about as much as we're going to be able to give you. The pictures do show you, I think, pretty accurately that any work that was done, any fill and excavation, any vegetation that may have been disturbed at the time of the dock construction, there are no negative impacts. It looks natural except for the dock. And so on the other conditional use elements, you know, we think for the general criteria, is the property suitable for a dock? Again, intrinsically so. It's a riverfront property. If you go take a boat ride up and down that area, you're going to see a lot of docks just like it. That's why people buy those properties. And so it's uniquely suitable for a riverfront property, and it's very tastefully done from the aesthetic value of it. It doesn't detract from the river at all. It's comparable to most of the decks out there, if not better. And again, the size is the issue, and we'll deal with that. If it has to be cut back, we have a plan. So we think the dock is kind of a straightforward issue. We'll get Karen Allen back engaged on when she gets back to shore up a couple of these little vegetation issues and submit that evidence. But I think we'll be able to demonstrate to you that all of the conditional use criteria has been satisfied. Now, the landscaping, Ms. Stewart didn't mention much about it, and we think it's kind of one of those things that is allowed even within the 100-foot setback. It's general terracing at grade level. I'll tell you the reason. I told you a little bit about the reason, and Ms. Hansen's going to testify a little bit about how important it is to her. But essentially, that they didn't change much. They really just made that property a little bit flatter, a little safer, and put some easily walkable paths in. We don't think that those are prohibited in the setback. We think the landscaping is generally allowed within in the area, and part of that evidence will be we've got Phil Henderson, who used to serve as a county board commissioner. He's familiar with the code. He's familiar with it. He's also been constructing in this community for a long time. He's also done land use work like me. And he's got some testimony on what he's observed over the past in how this code has been enforced and applied. He's also got photographs that he's going to get me. He says they're on a phone somewhere, and we'll get those in the open record period. He did a boat trip and looked at a lot of the same features up and down the river. And so, from our standpoint, when you're a homeowner, you're saying, okay, the code really doesn't define. It's got a definition of landscaping. It's got a definition of structure. It's got a couple definitions of structures. You're going to hear that in a minute. And so with some of the ambiguity in the code and the vagueness, owners are left with, well, how do I know what I can and can't do? Well, you look around and you go and you see 50 properties that have the same type of stuff, and well, that's got to be allowed. And Mr. Henderson's going to tell you from his experience, he thinks it is. And then the play equipment. There's really two angles. The variance is it's really prophylactic because I don't think it's necessary. And I know that the application doesn't talk about this, but again, I go back to what I try to do for my clients is work really, really hard to find approvability. And what I discovered here is that there's a definition of structure in the code that's probably broad enough to cover anything. Anything located on the ground could be a structure. And that would include, in theory, a tree. Because the position is a structure, landscaping can be a structure. And so anything would fall into that. I think there's a different definition for the 100-foot river setback. There's it's called the high watermark setback, and it's 100 feet from a natural river. This part of this property is on the natural river. But I have an argument I gave you, and I think it's legally correct that the definition of structure in the high water setback is different than the definition of a structure in the main section in DCC 18040330. There they define it as structures, buildings, or similar permanent fixtures can have to be 100 feet from the river. And then if you look in context, the code does allow structures in that 100-foot setback, certain structures. You have to go to the floodplain management section, which is where the high water setback appears. So it's in two places, but that's where the main high water river setback applies. It's in the floodplain management section, 18.96. And that's where that definition is. And in that same section, there are structures permitted that by nature and definition have to be at the river. Boat landings and associated structures, fish hatcheries, swimming areas. So you can have a swimming area with a lifeguard chair at the river in the setback. That's a structure under the main definition. So my argument that I've presented to you, and I'll expand on this in my final argument, is that is a different definition in context than the main definition, because we know in that setback there are structures that are permitted. And so and specifically 18.96.040G allows recreational uses and structures, related structures that don't have a significant impact on the floodwaters in the floodway. And so under that, we could apply for a conditional use to move this play equipment right next to the river in the 100-foot setback, and the code allows it. So my point is that setback distinguishes certain structures, that 100-foot setback. Certain structures can be if they don't have a significant impact on the floodway. And we will present evidence on that. These are far removed from the river. They're permanent. They're not like the floatable ones you get from Walmart. These are carefully crafted wood structures that were designed really to blend in. You know, Mr. Hansen wasn't immune to the fact that people had to see it. So he built it really nice. And so that's our argument there. I wanted to, and so we didn't address the variance criteria very much in my letter, and I'm not going to address it much here because I don't think we need to. I'm going to have Mr. Hansen tell you a little bit about why he did it, so that evidence is in the record for you, and his knowledge of the setbacks. But as far as the legal criteria for variances, I think I'll wait and address that in subsequent written material because I really think that our primary position is correct in that the setback doesn't apply to the play structures, just like it doesn't apply to the landscaping, and therefore we don't really need a variance. And so with that, I think I'll start by having Mr. Hansen come up and testify again, and he'll say his address and everything appropriate, won't you?
Yes. Ron
Welcome.
Hansen, 1810 Northeast Cliff Drive.
Oh, now, Mr. Hansen, I already set it up a little bit. I just want you to tell the hearings officer a little bit about, your thought process. What was in your head going into building this play equipment?
Well, the two structures that we're talking about, I believe, is a zip line landing. It's about 4 foot by 12 feet, made out of wood. Just a safety factor to get my grandkids and anybody else off the zip line. So we were using a ladder, which is pretty unsafe. So we did that. So that's the zip line landing. The other one's just a lookout tower play structure that you go up there and look. My grandkids go up there and play. That's basically it.
And what was your understanding of your ability to put them where you put them?
But I didn't know exactly where that 100-foot setback was at that time. We had that. What do they call it? Mapped out, surveyed, excuse me, later on. But I knew it was within it. I'm not I could figure out 100 feet. But I did think it pertained to play structures. And I know there's some questions that we had with you and Will a little bit, what play structures were or whatever. So I felt that those were okay. And I did not get a permit for those. They were play structures.
Okay, and then on the dock, you added a couple of guardrails.
Yes, sir.
Tell a hearings officer what those were for.
Well, they're just safety issues for my wife or my grandkids. And so all it is just 6x6 posts with some metal railings going around basically 1.5 sides of that.
And then as far as the plan for, if you have to cut it back, have you looked at whether it's feasible to cut that back without a significant amount of earth disturbance?
It'd be very easy to do. Those two wings that come off, and they're not necessary there anyway.
And then as far as the pathways and everything, I'll have Joni talk about her issues from her perspective, but tell the hearings officer what you were trying to create on that ground.
Well, we're just trying to get a safe situation for my wife or anybody else that would enjoy the property to get down to the dock. She can't walk over rough terrain. It's just not possible. And so we have the walkways are pavers. They're not pavement. They're not, but they're paved concrete paving stones down there.
And they're at grade?
They're at grade.
All right. I think that's all the questions and testimony I wanted to get from you for the hearing. So I appreciate it.
Thank you.
Thank you, Mr. Hansen.
Can you give them your name and address?
Yes, my name is Joni Hansen. My address is 1810 Northeast Cliff Drive in Bend, Oregon.
And Joni, I know it's not always easy to talk about, personal things, but I think the hearings officer needs to hear a little information from you on your physical condition, the details of it, and how it impacts your ability to use your property.
Okay. Since I was 18 years old, I was diagnosed with a disease called ankylosing spondylitis. It's an immune system issue, and I have arthritis all throughout my body. When I was 30 years old, I had my first 2 hip replacements. Now at 70 years old, I've had 5 hip replacements. I've had some toe joints removed on both feet. I've had fusing in my foot, my left foot. I've had 2 right shoulder replacements. And recently, this last year, I had to have 2 surgeries in my neck to fuse, and they put rods in there, and it has disturbed my ability to walk even further.
So, Joni, I appreciate that. So how important is it for you to have a level, stable environment to be mobile around your property?
Yes. It's near impossible for me to even step out on our lawn because can be unstable. So to be able to get around our property down to the dock, anywhere like that, I need a flat surface. We even have a ramp up to our front door of our cabin so that I can safely get into our home.
Thank you very much. I appreciate that.
Mhm.
I think that's
Thank you, Ms. Hanson.
We have another person that wants to testify, Phil Henderson.
Morning.
Good morning. No, I feel like I'm taking your chair.
Well, I used to sit up there.
That's what I thought.
It's a good experience. Yeah, my name's Phil Henderson. I live at 61517 Orion Drive.
Mr. Anderson, why don't we start by just giving Mr. Frank, to the extent he doesn't already know, a little bit of your background and what you've done in your career in the last 20, 30 years here in Deschutes County.
So I came here 36 years ago as a young attorney, and I practiced law for 14 years. And one of my client, and it was general civil practice, own my own practice here in Bend. And one of my bigger clients was a large construction company, house construction company, who built in really nice custom homes, started in Sun River and built throughout the whole region. And they recruited me to go to work for them. So I did, kind of as their legal counsel, and then became head of sales, and then I became president of the company. That's Sunforest Construction. They're built a ton of things here. And then after I worked there for 8 years, that was through the recession, I actually went out and had my own construction company for 6 years, building and remodeling significant houses. And it was at that time I ran for county commissioner and became a county commissioner, which was in 2016.
So do you have, I assume you have some experience working with the code and particularly setbacks?
Yeah, I think, and I draw more on my experience actually from the construction years where I had specific cases, have some experience with regard to being a decision maker as a commissioner and dealing with these kinds of cases. I guess starting with the construction side of it, 2 houses specifically that I was involved in were on the Deschutes River, upriver from the Hanson's house. The first one was a really large house built by actually an attorney out of San Francisco. That was right at the where the Fall River came into the Deschutes River. And so the setback issue, did you ask me about the setback or just?
Yeah, the river setback.
The river setback.
I'd like to hear about.
So the river setback issues was a big issue on that whole project, both the design of the house and then also what they could have around it. And it's been quite a number of years ago, but my biggest recollection was this issue of if the 100-year setback, the primary or 100-year flood setback, the primary issue or purpose for it was you don't want to put stuff out there that can float off in a flood. It was not visual like the scenic management one or something like that. It's really what's safe in the event of a flood. And so I remember on that house, there was questions of whether a separate building could be built out. And this was a pretty flat lot. And so there were issues with that, but then there was also issues with walkways. And my recollection was we could do the walkways with pavers because they're not likely to float off in a flood. I mean, the whole territory may be covered up, but they're like become part of the earth, so to speak. The second house that I did when I was a contractor on my own was just a little ways downriver from that, and it was a old cabin house right on the river that we did a significant remodel of. And there the issue was, I think it already was the house was maybe within the 100-foot floodplain because it had been built so long ago. But the issue was any additions had to be behind it because it was the structure of the house. You couldn't build the house out into the 100-foot or beyond the line that existed there. And then the other part was, well, then what could they do with landscaping? And I remember my recollection of the case is that they didn't have a problem with some of the things they put in that case or in that house with regard to both plantings and rocks that were just, features basically, but they're, what's that word? They're inorganic. They're just hard surface. They're not likely to float off in a 100-year flood. So that was kind of my interpretation.
Okay, and then you've been to the Hanson property before.
Yes.
And how do you know Ron?
Well, we grew up together. We were in Boy Scouts together in Hood River, so I've known him for quite a few years.
And have you done a survey of sorts along the river to kind of confirm your understanding of what is typically allowed in this river setback and what isn't?
Well, specifically with regard to this hearing, I didn't spend much time with the structures that he talked about because I wasn't really, that had, I think, been done or he was doing those, but we were looking more down closer to the dock. I'm real familiar with the dock. I took pictures underneath it when water was down, et cetera. But there were some rocks that were part of the, I think were just boulders that were kind of holding up, kind of retaining, but they've been blended into the point somewhat you can't even see parts of them. But they're just there. And then there's the pathway, the paver pathway comes down there and turns into the dock area.
Well, you mentioned me that you went up the river a time or two and took some pictures.
Yeah.
Can you talk about that a little bit?
Yeah. So one evening, we're friends and our wives are friends. We took this flotation boat and we actually did a tour, went down the river and then up the river. And I took quite a few pictures of different homes and docks, slips, kind of the terrain along the river.
And did you find consistency with what's on the Hanson property?
Well, yeah, I didn't find anything.
Did you find
There's a whole variety of things. Yeah. I did see that. And I saw things that maybe would be more objectionable too. I mean, there's quite a variety of things that have been in, and it's hard to tell what's grandfathered in and what was new and what permits got, but there's actual rock walls along some of them. I mean, which seems way more, that would be more structure-like because it's masonry walls put together than just rock, boulders or with dirt. So yeah, I did see a lot of that.
And you took some pictures?
Yes, I have quite a few.
You're gonna get them to me, right?
And I should be able to do that. So
Well, I appreciate your time this morning. Thank you.
yeah, thank you.
Anything else, sir?
No, I'm good.
Thank you for your testimony. Mr. Kobeck?
Yes, thank you. I'm going to kind of sum up a little bit more of how I see the issue. So I've covered the dock. It's a conditional use permit. We understand that. We're going to get a little bit more information from Ms. Allen. I'm going to continue to work on the size, but if not, we've got a plan to cut it back to be compliant. On the landscaping, I think you've heard what we're going to present. I think there's a solid legal argument that landscaping is not subject to any prohibition. Play equipment if we're correct that it's permitted within the setback under my legal analysis, then the only review we understand that could be required is landscape management. And Mr. Blackmore in the burden of proof has covered that. And you know, a picture is 1,000 words. You can see how well it fits in to the natural environment. It was designed that way. So we think we check off that box. And so the only other legal argument you'll see probably from me is I did a little research, and I'm convinced that under the American with Disabilities Act, zoning ordinances and their implementation are subject to the reasonable accommodation component of that. And so you'll probably hear from us on how we believe that the stable walking paths, regardless, even if they weren't otherwise approved, we think that there's an argument that the county has to apply its local laws in a way that would accommodate Joni Hansen's disability. So that's what we have. Again, I don't expect a lot of questions to get based on the context in which all the information has come in, but if you do have any, I'm here to answer them, and we can call anybody back that has already testified, and we will be renewing our request for an open record period. Thank you.
Thank you, sir. I have no questions at this time. I'm going to ask prematurely, Ms. Stewart, if you've addressed the ADA issue.
No, and Will Groves is going to speak.
Okay. I just didn't recall seeing it in anything that I'd read, which does not include the staff report.
Yeah, good morning.
Mr. Gross.
Planning manager. You know, we have run into a similar issue. There was a case called Thermalion that we had kind of a similar situation where a property owner had mobility issues, and we, under the ADA and with extensive findings, made a temporary arrangement that allowed a path through the wetlands that might not otherwise be permitted, because an argument was made that that type of pedestrian access could be made by a fully able-bodied person, but was not available to one of the residents of the property. It was carefully conditioned to be sure that the allowance was afforded specific to a person, and actually included requirements that the site be restored at such time as that individual was no longer on the site. So we've been down this path, and I wanted to note that we certainly want to make all affordances under the ADA possible. We've treated these as variances, and so since we have a variance open in this matter, it may be appropriate to make findings under that section. We can certainly put the Thermalion case in the record, and the county, you know, on its face doesn't have any objections to making, you know, reasonable accommodations under the ADA, similar to the Thermalion process. That was one that was done outside of a hearing process. So we may find that there's other obligations or maybe more robust findings that are appropriate, but generally we have no objection to, you know, appropriate ADA claims and making those accommodations through a land use decision.
You don't have to make a decision at this point in time, obviously, Mr. Kovac, but if Mr. Grove's suggestion is potentially agreeable to you, I'd look forward to, during the open record period, a suggested condition. If not, then you certainly have the right to argue something else. Okay. Thank you for your testimony, sir.
Thank you.
Anything else, Mr. Kovac?
No, sir. Thank you.
All right. Anyone else wishing to testify in support of the application?
No one on Zoom has raised their hand.
All right. Anyone available to testify in opposition if they'd raise their hands if they're online? Because I don't think anybody in the audience here in the hearing room is going to testify in opposition.
Hearings officer, no one on Zoom has raised their hand specifically. We do have the 4 participants who testified during the first hearing, but no hands are currently raised.
Okay, let me rephrase it, and then I'm going to ask you to do the same thing, so it seems repetitive. If anyone online wishes to testify in this particular case in opposition, I would ask that you raise your hand. Just wanted to make that as clear as possible.
One hand was raised.
Cool. Excellent.
My name is
And Donna P.
My name is Donna Pensinger, 17130 Wood Duck Court.
Before you start, I know we've done this before and it seems kind of silly. I need your first and last name and I need your address, please.
Can you hear me?
Yes, I can.
Oh, okay. I wasn't speaking loudly, I guess. My name is Donna Pensinger. My address is 17130 Wood Duck Court. I'm just opposite the Hanson property on the point. I spoke earlier to the slip, and what I wanted to say about the dock is that it is over twice what is allowed as far as the square footage. But I heard that Mr. Hanson is acknowledging that and willing to work to reduce that. It's a beautiful dock, and I wanted to just say that I appreciate that it's being acknowledged that it's way too big. Let's get back into whatever that requires. Let's get back into what is allowed within reason on the river. As far as the walkway, it again is, and this is not in opposition, actually, it's probably in support of. It isn't offensive, it is beautiful, it serves a very important purpose. And I don't think it's going, because it's in the 100-foot setback and on a hill, I guess if we did have a 100-foot flood, those stones would go into the river. But in fact, they are a natural product, and I wouldn't consider that to be a detriment to our land use. But I do want to say I hope that the dock situation gets rectified, and the play structure, again, that's up to the county. It's again up at the top of the hill. Doesn't seem like a big problem to me, but I'm not a land person. However, the dock is definitely something we need to make sure we get taken care of. Not to be able to do things without permits should not be okay. So, thank you.
Appreciate your testimony, ma'am. Anyone else wishing to testify, Mr.?
No one else on Zoom has raised their hand.
All right. Any final comments from you, Mr. Kovac?
No, sir. Thank you.
Ms. Stewart, any final comments?
I was just going to note, I will get an email from our building division to add to the record regarding landscape management review. It's only structures requiring a building permit are subject to it. I wrote the findings to be broad enough to cover the play structures, but in conversations we've had throughout this code enforcement process, my understanding is that they don't require any structural permits. So I'll add that so it's in the record for everyone to see.
Okay, and in somebody's comments, if staff responds, or certainly Mr. Kovac on behalf of the applicant, make sure you reiterate just that discussion. I'm taking pretty good notes, but sometimes I just want to make sure that I don't forget things, and so reiterate that in your findings regarding the non-permitting requirements of the play structures.
Yeah, no, I appreciate that.
Okay. All right. Anything else from you, Mr. Kovac?
No, sir.
All right. Let's talk about the open record period, and just this is my editorial comment. Is that both cases seem fairly intertwined to me, and having different open record periods to me appears, from my perspective, having to draft appears to be somewhat problematic, but that's just my editorial comment. I'm open to suggestions from both applicant and staff. Mr. You can go first.
No, staff is supportive of the similar open record period with December 31st, January 7th, and January 14th.
I couldn't agree with your comments more. They're related, and the reason we are requesting him is to get Ms. Allen back, so we would be supporting that same period.
Cool. All right. Appreciate it. Anything else from either of you before I get into Ms. Stewart talking about the logistics and time frames of open record period?
No, not from us.
Go ahead, Ms. Stewart.
Thank you. For the open record period, please keep in mind all submittals should be addressed to me. For email submittals, you can use my email address, audrey.stewart@deschutes.org. The county does not retrieve information from a website link or personal cloud storage device. It's your responsibility to submit all evidence and testimony you want the hearings officer to consider. Any electronic submittals must be received by the county server by 4 p.m. Please do not wait until the last minute to submit your evidence and testimony. The open record period for new evidence and testimony will be until 4 p.m. on Wednesday, December 31st. The rebuttal period will be until 4 p.m. on Wednesday, January 7th. And then the applicant will have until 4 p.m. on Wednesday, January 14th to submit their final legal argument. And with that, I'll turn it back over to the hearings officer.
Thank you. Any questions about that, Mr. Kovac?
No, sir.
All right. I have this habit. I just want to make sure people understand open record issues because I can't. I've been doing this a really long time, and the one issue that I just get really annoyed with is open record issues and what's submitted during that period of time, because I want to concentrate on the issues that you've raised today, and so let's deal with it. So December 31st, 4 p.m. Pursuant to the comments of Ms. Stewart, get your evidence in. Any new evidence that you wish to submit it. On January 7th, 2026. So January 7th, 2026 at 4 p.m. What you have the right to during that week is to submit evidence in response to what's already in the record. And finally, Mr. Kovac, the rebuttal period has a final argument or rebuttal period. An only applicant has the final argument rebuttal period, so no one else is allowed to submit evidence during that argument, whatever you want to submit. Only the applicant has the right to submit during that period of time. Mr. Kovac has heard this before, I think maybe staff has as well, is that if you want the record to close early, for example, during your final rebuttal period, our final argument period, you may make that request. And I underline, put in all caps and italics, request. It is a request because technically the record remains open unless I decided it's not going to be open any longer. So, Mr. Kovac, you have the right to submit a request to close the record early if you so wish. If you don't, then that's your business. Technically, I'm required to submit my decision or get my decision to you within 21 days, so approximately 21 days or less from the 14th of January 2026. I will issue a decision in this case. So anything further from staff?
No other comments.
Anything further from the applicant?
Thank you.
All right, I wish to, I didn't do this in the earlier hearing, but everyone who testified both in favor and in opposition has been very respectful, has been very kind. You told me what your opinions are. You've told me what you believe the evidence is, and I respect that. And you don't know how much. All hearings aren't this nice. And so consequently, when people do behave the way you have, it is very much respected from my perspective. So I thank you all. At this point in time, we'll close the hearing and wish you well.